As well aware that I am Dr. Jetling Elosa, running a YouTube channel titled as Love Speeches, in which my channel I am regularly posting my lectures on various facets of law and also world affairs. So today we discuss another important issue, that is the anti-defection and the role of the speaker in taking decisions and the judgments of the Supreme Court from time to time. So before embarking my lecture, I request all of you to subscribe to my channel, make your valuable comments and like my channel, and also share in your communities. You know that India is adapted, we can call it as a biggest democracy in the world. The festival of democracy comes from the grassroots to election to the Lok Sabha elections. So we celebrate the festival of democracy in every 5 years, and regularly we are conducting elections. 17 times elections were conducted, and for the parliament, to say Lok Sabha. You know, there is sometimes the elected members, they have crossing the floor from one party to other party because of the number of considerations, because money, power, other equations, they are crossing their loyalty to the political parties, and which was there heavily we have seen in 1960s. First time in 1967, a Haryana elected legislative member, his name was Ayaram. He crossed the party in a day for 3 times. 3 political parties he has crossed. The word Ayaram and Gayaram has come from 1967 onwards. And there is one estimate says that 1967 and 1971, out of 4,000 legislatures, 50% have crossed their loyalty from one party to other party. So the Gayarams are so widespread. To avoid this, the governments from time to time, in 1967, Y.B. Chavan committee was constituted, and the committee calculations or recommendations have been put before the parliament, and is referred to the joint parliamentary committee for fuller discussion. And again in 1979 we have seen the first non-Congress party government led by Morarji Desai was abruptly submitted resignation because of the crossing of 76 parliamentary members, Lok Sabha members, from one party to other party. Then the government has fallen. And when the Rajiv Gandhi was Prime Minister in 1985, he introduced a bill in the parliament that be called as the Anti-Defection Act or law. The main motto of this act to curb the defection, because we are getting bad name to our country, which is be called as the biggest democracy, but because of the political leaders, unscrupulous elements in the political parties and elected leaders, they are crossing their floors from one party to other. The then Prime Minister had made a historical step in the right direction, and the bill was introduced into the Rajiv Gandhi, I just told you. For that reason, we had amended the constitution by 52nd amendment, and the amendment was made on 30th of January 1985, and which came into force from the 15th of February 1985. So the act debars the crossing of the parties in an individual manner. So they may be group, they may allowed to cross, but individually they are not allowed to cross. As per that act is concerned, 10 paragraphs have been added to the act. And again, to give a kind of sharpening the act, we also carried out the 91st Amendment on the recommendations of the Pranab Mukherjee committee, which was constituted in 2003. And the 91st Amendment had made passed on the 2nd of January 2004. By this, the spirit in the political party is recognized. And this recommendation also, 91st Amendment, which was made in 2004, also recognized that at no point of time more than 15% of members should be, within 15% only the minister should be there, not more than that. A kind of a ceiling was introduced by this amendment. But time and again we are seeing in different states as well as in the central and the other levels, the crossings, groups are going from one political party to other parties, and destabilization of the governments, and the role of the speaker. The 52nd Amendment given a lot of powers to the speaker, because the speaker has the power to disqualify, because either it may be assembly or it may be Rajya Sabha or the Lok Sabha, who only has authority to disqualify. No other person take a decision of disqualification. But we are seeing speakers have been taking time, and they are delaying, adapting the delaying tactics. Recently in Telangana state, the 3 legislators, soon after completion of election in December, they crossed the party, the BRS party, to the Congress, ruling Congress party. And the speaker had not made any decision, in spite of representations were given by the BRS party to the speaker. He taking time. So ultimately, the MLA belonging to BRS party, Mr. Kaushik Reddy, filed a writ petition in this High Court of Telangana. Then Telangana High Court recently given a time to the Speaker of this Telangana Legislative Assembly to take a decision. Within 1 month time is given. If he is not taking the decision within 1 month, then the High Court will take the power of the Speaker. That was an order, very, very important order is made by the Telangana, judgment is made by the Telangana High Court. So we have seen not only this episode but also since the Anti-Defection Act was enacted in 1985-86, the speakers have playing the very manipulative decisions. You know, we have the speaker. Constitution of India guarantees the office of the speaker to the Lok Sabha or to Rajya Sabha under Article 101 Class 3 NDA and 102 Class 2. For it is in case of the legislature, councils, Article 190 Class 3 Subclass A and Article 191 Class 2. The speaker have certain privileges, no doubt about it, but they are misusing their power. So time and again, the Supreme Court has, in number of cases, have elaborately discussed the provisions of the Anti-Defection Law or Act and the power of the speakers in this direction and what kind of responsibility they may be holding, whether they are justifying their position or not. And in case called Ravi S. Nayak versus Union of India, which case is reported in 94, the Supreme Court held that the 10th schedule of the Constitution, which we inserted by 52nd Amendment, do also apply to an independent member who got elected independently, and if he joins any political party, he may be attracting the Anti-Defection Act. So that is a remarkable decision was rendered by the Supreme Court of India. In one more case called Orissa Legislative Assembly versus Utkar Keshavi Parida, case is reported in 2013, volume 11, SCC, page number 794. So in this case, Supreme Court has stated that if any person who is interested in maintaining the honor of the assembly or to say the constitution can file a case challenging the action of the speaker if he did not take action under the Anti-Defection Law. In one more case, Rajendra Singh Rana versus Swami Prasad Maurya. The case is reported in 2007, volume 14, SCC, page number 270. In this case, the Supreme Court held that if the elected member gives supporting letter other than to his political party to other government which is going to form, then it is nothing but it is a change of the party, and such member who gave the supporting letter is liable for under the provisions of the Anti-Defection Act. So it is a very remarkable and outside judgment delivered by the Supreme Court of India. Then another case, Shiva Sena crisis we have seen in 2022. So again the court has interfered where 2/3 of members they formed a faction and they joined. They have asserted that that is their own Shiva Sena. And in this case also, the courts have given the landmark judgment, and the court has stated that speaker decision is the final, and but which can be comes under the judicial review. In one more case, very important judgment, that is a Kyoto Holahan versus Jachil Hu, 1992, SCC, page number 657. In this case, Supreme Court has held that all anti-defection proceedings which are undertaken by the speaker are be called as a quasi-judicial method only. So, the principles of the quasi-judicial methods will also apply to these proceedings. That means that they should be given a notice, hearing should be there, and after only proper inquiry only they have to take, speaker has to take the decision. So that is another important judgment delivered by the speaker. In one more case where who is unattached member is discussed by the Supreme Court, that is the G. Vishwanathan versus Tamil Nadu Legislative Assembly, 1996, volume 2, SCC, page number 353. In this case, Supreme Court clearly demarcated who is attached, who is not attached member. Suppose a political party expels a member for anti-political activity. Suppose the member do not join the other political party, then such member is called unattached member. And unattached member also should not indulge into the independent activity of disobeying his own political party. So then I just told you that speakers have taken much time in taking the decisions. So there some more cases are there in the Supreme Court, like Kaisan Megha Chandra Singh versus Manipur Legislative Assembly. The case is reported in 2020 SC. So in this case, the Supreme Court has set out that though there is no time limit is prescribed in the anti-defection law or the constitution for taking a decision of the speaker with regard to the anti-defection matter, but the speakers are bound to give or pronounce their judgment within reasonable time. They should not take unreasonable time. So that is the reason the Kaushik Reddy in Telangana, the BRS party leader, MLA has filed a case and successfully got an order from the Telangana High Court. Then sometimes what may happen, the speaker may become incapacitated due to number of reasons, because he may be suspended or maybe some other reasons. So that also been dealt in a case called the Nahim Rehiya with Bamang Felix versus Arunachal Pradesh Legislative Assembly, 2016, volume 8, SCC, in which, in this case, the speaker has become incapacitated due to the political unrest. Then, can he take a decision? So Supreme Court has clearly stated that his position was under cloud and he should not take the decision of the another cloud. So he is debarred to take the decision. That was a clear gist of this judgment of the Supreme Court. Then as well aware that the if the disqualification is made by the speaker, either by by the central or the state levels, that matter has to be referred to the president or governor respectively, and the president or governor, they will further refer the matter to the election commission, and that is there enshrined in the Constitution of India. And in one more case dealing with this matter, the Supreme Court in Lily Thomas versus Union of India 2000, volume 6 SCC. So the Supreme Court has stated that it is a mandatory on the part of the speaker to refer the matter to the president or governor, as the case may be, because the law is prescribing like that. So they have to observe the law, and they are not above the law. So the office of the speaker once upon a time was a highly esteemed regarded, because changing of time, because of the commercialities, because of self-interest, that regard has gone to the occupants of the office. So that is the reason we are going to courts, and the courts have been telling time and again that nobody is superior. Law is superior. Everybody has to follow the principles which are there in the Constitution. Law is above to them. Thank you, and patiently hearing my lecture. Thank you, one and all.